Cool. Okay. What I want to do is really catch people up on council tax, and I think everybody here knows we were in the High Court on Wednesday for what's called a permission for renewal for a judicial review. What is a judicial review? Judicial review is a pathway for remedy to sort out questions of law. So these are not disputing questions of fact, but questions of law. Now, tomorrow in the constitutional stuff, I'll show you that the courts have a duty under statute law, i.e. Parliament has instructed them, okay, that the courts must determine the lawfulness of acts of Parliament. I.e. Parliament, by their own admission, is not supreme creator of law. And that's also reaffirmed in the, not only in the Senior Courts Act 1981, but also in the Constitutional Reform Act 2005. So Parliament itself is under no illusion that they're supreme. Okay? And this whole thing of supremacy of supreme creator of law, Parliament being the supreme creator of law, is actually, and tomorrow I'll show you, an admission by the judiciary of breaching their constitutional duties of independence and the separation of powers and the rule of law, by the judiciary themselves taking it upon them to decide that Parliament is the supreme creator of law. Yet everybody is equal under the law. Nobody's above the law, and it's the judiciary that have created this illusion and uphold this illusion. And this is so fundamentally misunderstood, but tomorrow we'll cover that in detail. So with the judicial review, it's about questions of law, and really we had 9 questions of law which we put forward. We'll go through each question of law because that's one of the things the judge will have to go through to determine if we have reasonable grounds to bring these questions of law to waste the High Court's time. So there are different tests. We'll talk about the different tests. Now, like we've been saying, we started this 3 years ago, April 22, 1st of April 22, as an April Fool's joke, but it actually was not an April Fool's joke. We intentionally used that day, being the new council tax year. And we managed to get it out at 7 p.m. and last few minutes Brian was making the additions or corrections to the PDF, and then we couldn't upload the darn things and all sorts of stuff, but we got it out in time. That was version 1. How did we come to version 1? Version 1 was basically research that we've done. We looked at acts of Parliament, we looked at case law which we were aware of at the time, and we created a theory of what should be happening according to the evidence before us at the time. Okay? So we took the theory and that was updated each year. But you have a theory, what do you do next? You test it. You test your theory. Am I right? Am I wrong? And where you're wrong, you feed back and modify your theory. Okay? And so, modify. Retest. And this here is what's known as an iterative process. We learn from our mistakes. And thankfully, many people had faith in our original theory to have the courage to test it, who fed back, which resulted in modifications, and we've been through this. So the first iteration was version 1, 22, then we had version 2, where we updated it in, I don't even know if I've managed to get that updated. We've managed to update parts of the thing. And basically, we're going through a major update now. But again, because my time's been so involved with this judicial review, I just haven't managed to get it done. So, does anybody know what this here is? Feedback loop. What's it better known as? The scientific principles. Law is science. It is not an art. Okay? So, we went through magistrates' courts. We tested our theory, i.e. we identified how should it work. Okay, the system. How is the system designed? And I can tell you the system is absolutely incredible. It is fantastic. The system is not the problem we face, and very quickly during our test and feedback, the problem are the operators of the system. Who are the operators? The judiciary. The judiciary includes judges, but solicitors are officers of the court, therefore they form part of the judiciary, and barristers have some sort of funny little thing. They're actually not officers of the court, but they are basically, they don't call them counsel for nothing, they are independent advisors. However, all of them under the Legal Services Act 2007 are duty bound to uphold the rule of law, the constitutional principle of the rule of law, and provide the court with all relevant law, because their duty is to the court, and then comes the client number 4. Okay? Rule of law, their duties to the court, of which the primary duty is to put the court with all relevant law, and then comes their client. And that's exactly how they should be advising their clients. Under my obligations to the rule of law, society has granted me the privilege of being a monopoly, and I take that privilege serious. They've entrusted me to uphold the law on their part, and that there's where the system fails. They are not doing the job which we, the public, have entrusted them in. But worse, the judges are not holding them to account for not doing their job. If the idiots are arguing before the judge, what is the judge's job? To determine what is the law, and if you're just given a load of waffle without any authority, how the hell can you blame the judges? The way you can blame the judges is they need to hold the officers of the court and the barristers, the counsels, accountable for failing in their duty and thereby breaching the Legal Services Act 2007. Because that will be a massive kick up the arse.
Is that not malfeasance in public office?
Well, various things. I don't want to go into the details of exactly, but yes. Basically, it's simply a breach of trust. Okay? So the judges need to start to understand the problem, and I think Wednesday I highlighted the problem because off the top of my head I believe that the barrister failed to provide the court with one authority to assist the court to resolve the dispute, and therefore the barrister has failed in what we, the public, have entrusted them to. In theory, like I said, a fantastic system. All you need to do is go to one privileged person who should provide all the law relevant to the dispute. This part of the legal profession is not adversarial. Their job is to put the court with the relevant law. Now, relevant law includes dissenting opinions. However, there's this little catch act that they put in. Okay? It's all relevant law within your knowledge. Therefore, if we put them with the knowledge of some law, they actually have a legal duty to respond. And we've put lots of authorities to them, and none of those authorities have been rebutted under the fundamental principle of the rule of law, stare decisis. That's the foundation of we are all equal under the law. Okay? A precedent is the logic and reason applied to the evidence to resolve the dispute. So it's the logic and reason which is applied to where it can equitably resolve the dispute. So it's not case specific. Okay? And you get barristers saying, oh, but that is from, the tribunal. It doesn't apply here. The legal profession is that badly trained, they actually do not, most of them that I've come across, understand even what a precedent is. That's how bad this is. Okay? And so, what this claim is all about is applying what we've learned to, in this one, my council tax case. Alright? So this is my personal tax affairs, however PeaceKeepers have brought it. And the reason we've done it in PeaceKeepers, unlike what the councils and the councils have responded, they've said it is to cover Marc's cost issues. Marc's trying to manage all his risk of costs. It isn't. This is way bigger than Marc. Yes, this case is about Marc's liability order that was made. However, I'm a director and trustee of PeaceKeepers. Lance was there. He was witnessing this. Brian didn't get the video link. 3 directors and trustees were directly affected by that decision made by District Judge HEARI1. So it's much bigger than just me, this particular issue. And so the thing about PeaceKeepers standing is it allows us to bring things together, because what I've complained about here, all of us have witnessed and fed back. This is happening in all the magistrates' courts. Okay? So, basically, Sean Jones at the Ministry of Justice, or depending on which hat she wears, HMCTS, depends on how she wants to answer the FOI, but she answers FOIs from both Ministry of Justice and HMCTS.
Or Elizabeth Jones, the barrister.
The judiciary is meant to be independent, and she is directly controlling the legal advisors in the courts. Now, you get 3 different types of judges in the magistrates' courts. You get what are called lay magistrates. Those are untrained, they've not been through the legal training. Magistrates, they're all called justices of the peace. That's one level, which makes you think, if ignorance of the law is no excuse, why on earth do they need a legal advisor? Okay? The role of the legal advisor, the way Sean Jones is controlling them, is through the lay magistrates. Council tax matters are done in what's called bulk listings. There's nothing wrong with a bulk listing. It's a very efficient way to run the courts. Instead of making a time for 2,500 people, as it was in my original case, okay, you come at 10 o'clock, you come 10 minutes later, 10, 90% of the people don't even turn up. Well, in fact, 90% of the people pay when they get a summons. Of the 10% that remains, 90% will just bitch and moan and will cede. Of the 1% that's left, they've got these people dressed up in black who everybody thinks is outside there to help you. Okay? And they'll take you and say, Daniela, how are you struggling? Can you pay 50p a month? Yeah, just sign here. I now have created a contract. And if she breaches that contract, the contract creates the law between us. So if she breaches the contract, then I can go and get lawful remedy in the court. And then there's the us few who really are persistent. We're not even 1 in 1,000. It would be lovely if we were 1 in 1,000 challenging this, but it'll come. Okay? Who want to go and have our time in front of the magistrates. Initially, when we started coming with witnesses, they didn't know what was going on yet. Witnesses, oh, yeah, no, you're allowed in. Yeah, of course you're allowed in. Until they saw what we were being fed back. Then we modified our theory, and then the resistance started. They do not like us going into their courts. Why? Because we're watching justice being done in our names, and we are not happy about the way they're doing it. They're being observed, and once they're observed, their behavior changes. So we've had a pushback against public going into the magistrates' courts for council tax hearings. However, we're testing new things, getting new feedback, and we are hammering them on it. They can't keep us out of the courts anymore. Whatever their nonsense excuses are, they really are struggling to keep us out of the courts. And what's more significant is the theory has been refined and refined and refined. I.e., we start off with 8 exits, because there are 8 different possibilities. And what we're doing is just shutting in one door, i.e. we're starting to focus what is the true problem. Okay? So the true problem is the due process of law. Now, Lord Diplock in Attorney General versus Times in 1974 told you how the courts must operate. The first job of the court, the first thing is, the monarch, through his promise, must provide constitutionally established courts. The first job then of the court. Now, what is a court? There's a noun and there's a verb. The noun is the building, okay, where the court is sitting, and the court is the verb that actually takes the action. The named individuals. And therefore, on a judgment, you have the right to know who has made judgment against you. Just like you have the right to know who's made an accusation against you. Just like you have the right to defend yourself against the accusation. Okay? And this is clear in the Magistrates Court Act, section 148. It's the sitting justices of the peace which create the court. Therefore, anything that comes out of there without a name of the judicial officer who made it is toilet paper. It's utter rubbish. And because with lay magistrates, the legal advisors are part of the statutory requirement for lay magistrates. They are part of the decision-making process. And thank you, Sean Jones, for this, by the way. I did find the case law, even though you didn't write it inside the Justice Clerk's side of the manual. Okay? It's the Derby case, 2023, I think. I can't remember off the top of my head, but anyway, that affirms, because the legal advisor is part of the decision-making process, their name also public. Therefore, with lay magistrates, you need the names of the justices of the lay magistrates, plus the legal advisors to make any document lawful. Without those names, there is nothing from the court. So the way that she does this is multifaceted, largely by changing the civil procedure rules in the magistrates' court. The magistrates' court has its own civil procedure rules. They are different from the senior court's civil procedure rules, or CPR as many people are familiar with. Many people seem to think that the civil procedure rules of the senior courts, so that's the Crown Court, High Court and Appeal Court, those are the senior courts, and the county court actually also is bound by the civil procedure rules, but is not a senior court. And the Supreme Court purely deals with matters of law, and so has their own civil procedure rules for that. So we've got 3 different sets of civil procedure rules, which all fundamentally are pretty good, until where Sean Jones gets her hands on them. So what she does is she puts out a lot of information to the legal advisors, allegedly to uphold the rule of law. A lot of that information is fraudulent, misrepresentation. She is certainly well aware of what we're doing. We've got a lot of correspondence, haven't we, Joe, from her? Okay, 2/4, what we're doing collectively. Okay, and she contradicts herself even, and it's clear that she is blocking off what must be so obvious to her to try and shut this down. Why is this? The reason for this is, unlike what most people believe and are told, we do not have 2 justice systems, civil and criminal, in this country. We have 3. And the Magistrates Court Civil Division is the major culprit of number 3. However, that's assisted by the County Court as well. What they've done is Parliament has removed from the judiciary, the independent judiciary, enforcement of what is nothing more than a statutory claim. It's a belief that statute law creates an obligation. So it's a statutory demand. That's it. Based upon a belief which the courts are voluntarily just doing it. And you know what's their excuse? Because Parliament's democratically elected. Now, if you can tell me what the hell democracy's got to do with law, and we'll be looking at this tomorrow, the courts have abdicated their duty that we've entrusted with them, the rule of law. They are the balance. That's what an independent judiciary is. Somewhere, anybody can go to have a dispute resolved, and specifically between those governing and the governed. So this tripod, as they sell you with the separation of powers, is another misnomer. It's not a tripod. It's scales of justice. You have the independent judiciary, you have the governed, and those governing. And it's to make sure those governing govern lawfully. So that's the basis of the judicial review. So this third jurisdiction of the courts, basically I can't find a better description as Stasi, Star Chamber, Government Revenue Courts services. Okay? Anything where there's no harm done to anybody, that is how they extort money from you. And Human Rights Act, Protocol 2, I think it's Article 1, your right to private property is subject to you giving the mafia bosses whatever they want. Because if you don't, they will steal it from you through this third court system, their government revenue Stasi, Star Chamber courts. Okay? and give you the illusion that you have the rule of law, because everybody knows a magistrate's court is a court. Part of the independent judicial.
Why are lay magistrates even there?
Well, there's a long history behind magistrates. We'll talk about this tomorrow in the constitutional course. Basically, fundamentally, on the continent, the European system, how does that fundamentally differ from the common law system that we know, is that in the continental system, it's the magistrates who investigate. It's not an adversarial system between the barristers, the two parties. So the magistrate is directing the investigation for evidence and everything. Whereas here, that's part of the prosecution or the defense.
But the magistrate is a highly qualified law professional.
And this is the problem we face. At the entry level, in theory, is where we want to resolve all these problems. And they've got the least educated, least experienced judges, the least experienced, wet behind the ears solicitors, and the ones that really can't make big money operating in there. And so the quality of understanding and knowledge is pretty close to 10%. They have an honest belief legislation is law. That's it. That's what they believe. It's true to them. Okay? The question is, in a court of law, we need to test that truth. And this is what we do. So, we put in the judicial review application. So Darren's was put in first into London. And mine went in about 10 days later, because my judgment was after his, or maybe a month later. They dealt with Darren's judgment in, must have been about 3 weeks, something like that, before they issued it. Okay, we filed the judicial review application for the commission. It took them about 2 or 3 weeks to respond to Darren's. Mine went in on the 20th of December, and it was only issued on the 25th of January, or 24th of January, something like that. And what actually happened was, they thought there was the same application, okay? Even though the one's got number 1 and the other one's got number 2, and MAP versus EM. So, shit can happen. I have no problem with that. And they held their hands up promptly and said, oops, we're really sorry, and fixed the problem and issued it once. I'd spent 3 days, 3 hours a day, and on the 4th day, I managed to get, I thought, damn this, I'm going to start calling before 9 o'clock. And I managed to get an answer, spoke to somebody. They issued the claim that morning, forgot to stamp the thing, so I had to email them back and say, hey, wait, I need the stamp on this thing. And they sent that back in the afternoon. So really, with that understanding, it's been tested. All of this stuff is evidence of what we're saying. Okay? So, when people say the system is corrupt, I would say no, the system is not corrupt. The system is bloody good. It's the operators of the system. And we need to start distinguishing so that we focus on the problem. The problem is the quality of the judicial officers and the quality of the legal professionals. That is where the problems are. They are both equally to blame, I believe. The legal profession is failing in putting the court with all relevant law. And on Wednesday, it was pretty damn obvious what was going on to those that watched it. And at time, the judges stepped up and basically said, I'm holding you in contempt of court. You have breached your duty to the court to put the court with all relevant law. And if you do it again, I'm going to have your license cut. That there, so simple, will rapidly help to resolve what's going on. So the judicial review, basically, if you can see it, what I've got here, and if Dame Hill's watching this, or ever does watch this, I have no idea if the judgment's been sent. We're getting what's called a draft reserved judgment, which means I cannot talk about it when I receive it until it's handed down. Okay? So what I've done is...
about time scale, do you know when you'll...
No idea. I mean, I'm guessing it'll be by the end of next week.
Okay.
No, I mean, she's an amazing judge. She really, really is very, very good. I can't fault her. And she really made sure she explored all avenues. She gave you plenty of opportunity. She made sure she understood not only my stuff, she did the same to the council, gave them all opportunity, including bringing in new arguments, not only from their skeleton argument, but on the day even further new arguments. Okay? I have no problem with that because it's about truth. If we're wrong, we need to know we're wrong and why we're wrong. Remember, precedent is logic and reason. Okay? So what I've done is, we're playing with AI, just like as everybody else. However, we use it in a very controlled manner. So I do the research and then we'll restrict the AI to that, to test it. Okay? And my writing style, okay, is not the easiest to understand and that. And so largely the AI gives a much nicer flow to the arguments, builds the arguments better, using multiple models and that. And then what we do is merge, and things I'll change into my language. You know, if I feel it's left something out or not stressed it enough, I'll modify. And Hugh's seen some of this stuff, and I think it's pretty obvious where I've modified versus what it is. Okay, but at the end of the day, that's what it is. So what I thought I'd do and this is what we're going on to now, is let's see how AI would make this judgment and why. So what we've done is fed in the bundles. So it's got all of the submissions that were before the Lady Justice, Danielle. It's got a lot of people made comments and fed back that were attending and viewing. So key elements of that there I've merged, fed that in. So that there is subjective. Okay? And then I've said, could you make a draft judgment based upon this information? What was before the court?
Mark, can I interrupt?
Yeah.
Do you remember you were supposed to give
yes.
references?
Yeah, okay. Now, the way that this works is, because it is about fair and just, so because they'd introduced new arguments after, and which I had not had the opportunity to rebut, she did put me under a bit of pressure and said, get it over lunch. And I just walked back in afterwards and said, I'm sorry, I couldn't get it over lunch. I need to make further submissions. And she said yes. Okay? It's about the truth. So if somebody introduces something new at the hearing, you need an adequate opportunity to rebut. What was Calvin talking about this morning? I need the evidence to be able to analyze it and give you a response. Okay?
Don't you have to run it by you, the other side, if you accept?
Sorry?
Doesn't the other side have to run by you if you accept them introducing new evidence?
Actually, it should be done by application where they should pay.
Exactly.
Okay?
Yeah.
The correct civil procedure rules, you should pay through an application to basically amend your statement of case or bring in new arguments. Okay? It's not about the money, Daniela. It's about, I don't play these procedural nonsense
But
games.
how is it that it was accepted for them to submit new evidence at the hearing? This is what I don't think.
I didn't object. I had no problem with it.
Oh, you didn't object?
I could have objected if I wanted. But I'm not interested in playing these stupid petty little games. To me it's equity, substance over form. It's about the search of truth.
Okay.
So they tried and this new stuff that they were using was this petty nonsense, and they didn't get away with it. So with that background, what I want to do is show you what are the things that what does the judge need to do. Okay, so anyway, the format of the judgment, hopefully people can see it on the TV. All right, I don't think the brightness is enough.
No, that's it.
So, don't know if you want to come closer, it doesn't matter. Okay, so the format of a judgment is always pretty similar. You get who are the parties, and then who's the justice that's sitting, and then it starts with an introduction. So I'll pretty much, the beginning is pretty much it. Okay, the matter before the court, this application is permission to apply for judicial review brought by the claimant, the PeaceKeepers Foundation, against Liverpool and Knowsley Magistrates Court, the defendant, and Liverpool City Council, the interested party. The application challenges a series of decisions and actions arising from council tax liability order proceedings against Marc, a director and trustee of the foundation. Right, so a lot of people are having an issue about how do we go about this process of appealing abuses of process within the magistrates' courts. And really, who's made the decision that you're appealing? The sitting magistrates. So who should be the defendant? The sitting magistrates. And who's affected by the decision? The interested party. Okay? And it's interesting, in Darren's judgment, the judge followed the barrister's submissions and said you can't be a judge in your own cause. I.e., the magistrate court can't be a judge in their own cause. Go back to basics. What is a magistrate's court? The sitting justices. So, I'm sorry, those sitting justices can't be a judge in their own cause, but other people at that level or higher can. Why? We all have a duty to keep the peace, and that includes a duty when we see others causing harm to do what we can to fix the problem. But essentially, when we're wrong, what's wrong with holding your hands up and saying, oops, I'm sorry, I now understand I was wrong, and therefore I've changed my decision to that. Okay? So basically, really, for a judge to change their decision, it takes a lot of courage, it takes a lot of looking inside yourself. And unfortunately, we don't have many that do that. So, when we start it again, go back to that loop, section 142 is for, they allege criminal matters for courts to correct their mistakes. I.e., saying to the court, you guys messed up, fix it. However, the magistrates' courts has two jurisdictions, civil and criminal. And because lawyers make lots of money playing with definitions of words, wasting people's time, because they do not understand the difference. The rules of equity have prevailed in the English legal system under common law since 1615. And still today, nobody knows this. Nobody understands this. Okay? So, what is the substance of what Parliament has said to magistrates' courts? So this is lay magistrates, deputy district judge, in brackets, magistrates, and district judge, in brackets, magistrates, the top two being paid professionals, trained, and the bottom ones being laid, advised by legal advisors. do. And how did I divert on that one? Anyway, we'll get to it. So it's about the substance of what, Parliament. The substance of what Parliament said was, you messed up, fix it. I give you statutory authority to do it. In fact, I'm statutory telling you, you have to do it if you find an error. However, the way that it's worded, okay, it uses the word offender. And therefore, all of this money is wasted arguing about the word offender. Because it says offender, Parliament just intended this to be criminal. They can only fix their own criminal mistakes, but the civil ones, no, they can't do that. I mean, what an absurd notion. There are hundreds of cases, hundreds of thousands of pounds have been wasted on this stupidity, where equity, which prevails, is substance over form. Why has Parliament said anything? If you make a mistake, fix it. Therefore, it doesn't matter if it's civil or criminal. That's how simple this is to resolve the stuff. Yet, they just make utter nonsense out of it. So, to come around it, because the courts sort of feel, oh yeah, no, maybe we should fix these mistakes. Do you know what they've done is? They've used something called inherent jurisdiction. So, they made up this thing called inherent jurisdiction. If I mess up, I've got to fix it. And that way is how they deal with civil appeals. I mean, the insanity is just beyond words. And the waste of money is just unimaginable. The waste of courts' time. All the courts are complaining, oh, we've got too much to do. The reason you've got too much to do is you don't hold your officers to account. The judges don't hold their officers to account. So you get endless adjournments. You heard this morning, Calvin's case. This is not only one. He's got another case where there's been 5 adjournments. For the CPS, that's fine. Don't worry, CPS. They're the officers of the court. Okay? If you do not do something, do you think they'll give you adjournment? You have to fight for it. And you're lucky if they give it to you. Total bias. Yet, to stop this nonsense, it takes one judge to stand up to the CPS and says, sorry, you breached the court order. I told you you must disclose within 28 days. You failed to. Throw it out. You know how fast that will get around the CPS. They will stop bringing this nonsense into the courts. They will actually start doing their jobs. Half of them won't be needed anymore. In fact, more than half won't be needed. Because generally cases are adjourned at least once. And if it's adjourned once, it means already half is not needed. So if we stop this nonsense, all of a sudden access to the law becomes much more manageable, plus the courts haven't got this overload. The judges need to step up to hold their officers to account. That will force also, if they do not put the court with all relevant law. The cop-out clause is in your knowledge, but once somebody's put it with your knowledge, you have a duty to put the court with them. So catch them out once or twice with this. So we've got Ashby versus White, 1704 House of Lords Appeal. Since Sharon's case, okay, that judgment, Sharon's case, we'd only researched, remember our theory, had reached the 1703 Ashby versus White case. As the research continued, the theory was updated to the 1704 House of Lords appeal. Okay? And that appeal makes it absolutely clear, by the votes of Commons, they cannot interfere with the common law, i.e. the common law is outside of the jurisdiction and above Parliament, and they cannot interfere with property rights. Both specific issues we're talking about in the Local Government Finance Act 92. Okay? So the interested party, therefore, in effect, what's going on here is, yes, I'm the defendant, I made the mistake. I've not fixed the mistake myself, and therefore I've forced Daniela to bring it to the court's attention to resolve this dispute because she still believes I made a mistake. She's making it against me, the magistrate, who she believes made the mistake. So what they do to try and maintain neutrality is, it's sort of good manners to say, right, maybe I did make a mistake, okay, I'm not getting involved in this. I don't want to be seen to bias the decision that's coming out of here, and therefore they do not make submissions. And that's where the interested party comes in. Because the interested party is affected, and solicitors and barristers are what? Officers of the court. Does it really matter if the interested party provides them or the defendant? It doesn't, because they work for the court. So when people say, oh no, you know, the interested party, and this, that, the other, that's what's going on. And it's in order to minimize being accused of bias. Okay, please investigate my mistake. I'm not going to try and push anything. You guys sort it out. If I was wrong, tell me I was wrong, and I'll learn from my mistakes. So does that make sense? Okay, so that's why you have an interested party. So the question is Marc an interested party? Of course he is, it's my direct tax thing. Yeah. But we'll get onto that. So the next thing basically is, well, why are you guys here? The original application for permission was refused on papers. What does that mean? Basically, in the first instance, to see if a claim has got any merit, or if it's just an utter waste of the court's time, the court will deal with it, what they call, okay, Marc's given this in, he served it on the defendant, he served it on the interested party, they've seen what Marc's complaint is, and they've replied to Marc's complaint, and now we've got both sides of the story. Let's see if there's any substance which makes it worth. Is the dispute of sufficient magnitude and importance to waste the High Court's time to resolve this? Okay, so on papers basically means without people, a judge sitting, making a decision based on the evidence before him from both sides, and then should give their reasons, because if you're wrong and somebody just says, no, you're wrong, how does that help you change your behavior or understand why you're wrong? There's a duty under the open justice principle to explain why you're wrong. Okay? Why is so important, because if we understand why, that was when we start to change our behavior. If I'm wrong, I'm wrong. You know, I might be angry about it, I might be pissed off, whatever, but once I really understand I'm wrong, I don't do it. So he read the party's submissions, and submissions is a word I think we need to start using more. We need to stop using the word argument. Okay, there is something in words, all right? Argument is a direct attack of somebody's belief. So submissions, I submit, this is my side of the story. Okay? You submit, this is your side of the story. Once we've got both sides of the story, then we can start to create a logical argument as to why ours is right and yours is wrong from both sides. And when you do that, basically the whole idea is to what's called narrow the issues. Okay, we started with a list of 9 complaints. The first complaint was District Judge Healy did not provide a certificate of refusal to state a case for the opinion of the High Court. They replied and said, but we have. And I said, what? I've never seen it. I asked them for evidence. They gave me evidence, and it's most likely either it went into my junk mail folder because it was a different email address that I've got for the court, or I might have deleted it by mistake. I don't know. But from the evidence I saw, no, more likely I messed up than they messed up. So I removed ground one because I was satisfied now, based upon the evidence before me, more likely I made the mistake than they did. I've not got to waste the court's time on this. So ground one I struck out in response to the evidence that was given to me.
Was
So
you
na-
satisfactory with the evidence?
I'm satisfied, yeah.
Okay.
I mean, it could have been fabricated, the evidence, but the evidence satisfied me that he'd done it, but it does not affect anything else. It only affects ground one. Nothing else is affected by it anyway. So that there's narrowed the issues from 9 to 8. We couldn't settle any of the other ones. So, and that there's called, you concede a point, but the idea of this exchange is to narrow the issues. See if the kiddies can sort some of this stuff out themselves by talking to one another in a, pen on paper instead of screaming and shouting. Okay? And he refused permission to proceed for judicial review on 4 grounds. The first ground was lack of standing, i.e. peacekeepers have got nothing to do with this. They shouldn't be bringing this case at all. Therefore, throw it out. The second ground was delay. They alleged that I had not submitted the claim in time. The third ground was that there was somewhere else I could get remedy, because the judicial review is a last resort. If you can't get help and fixed in the specialist courts and stuff like that, so basically a planning matter needs to go through the planning court because that's where the expertise of planning is. Family matters go through and they've set up specialist courts, which makes absolute sense. At least you've got a high knowledge base in that particular area of law, and the judges don't have to be re-educated because the judges deal with everything under the sun. Okay, so there's an absolute rational sense for specialists. So basically what the third reason was, Marc should have gone somewhere else to get remedy before he came to judicial review. And then the fourth one is a novel one. I still haven't found out what it means really. All the remaining 8 grounds lack perceptible merit. Now basically they've got a scale. Totally without merit means this is utter garbage. Without merit means this is almost utter garbage, but there's no way that you've got a reasonable chance of success. But this perceptible merit's a new one on here, and I really don't know what it means. Okay, then.
So, what's the basis upon which they decide that? Upon case law? Or
Well, we'll be going through this. Okay, because remember we said part of every judgment I need to understand. Why did you say this? Where's your evidence? Show me the logic and reason how you reached the conclusion from the evidence before you. Because without reasons, it's toilet paper.
And about the standing, I thought that
We'll go through in detail each ground. Okay? So what we're going to look at is, what was District Judge Dan Hill's job to deal with this verbal application. Because it was dealt with in papers, I haven't had my say. Okay? And therefore you can apply for a verbal hearing. So that you can have your say and go away and say, whew, I've said everything. I don't think I've forgotten anything. I've said everything. And I'm confident they understand my problem properly. So that's the idea then of the in-person hearing. So it gives you a second opportunity. Instead of the way you write, do you have substance in what you speak? Okay? Which gives this claim merit. So her job, she was doing the in-person hearing or a renewal application for permission to appeal. Those were the 4 grounds. So she had to deal with 4 issues. One is standing. 2 is delay. 3 is alternative remedy. And 4 was waste of time. And that's what the judge said, basically, is what he's saying politely. You're wasting the court's time. Okay? So these are the 4 issues that she had to deal with. Okay? This issue here, no perceptible merit, related to grounds 2 through 9. And we'll look at each of those grounds. Okay? The alternate remedy, the council was arguing, valuation tribunal is where I should have gone for this. I shouldn't have gone to the High Court for judicial review. I should have gone to the valuation tribunal. The delay was that basically they don't know the difference between words, issue versus submission versus issue.
Submission.
So the Liverpool Council and Ockleton, Judge Ockleton, are confused between the words submit the application. It's actually apply, okay, and rather than submit in the civil procedure rules, the word is file. So filing your application, and the court issuing the application. Okay, that's what this argument boils down to. Understanding is basically the argument was Marc's personal tax matters.
But Mark, I'm really sorry, I have to understand something about procedure before you.
Yeah?
During the hearing, it appeared that it was the barrister was arguing points like standing, and you said 10 minutes ago that it was Judge Healy who said there is no standing.
No. The barrister from the council, Liverpool City Council's barrister, was saying peacekeepers have no standing because it's Marc's personal tax matters.
And
this has got nothing to do with peacekeepers.
And didn't you say that Judge Healy also said there was no standing?
Yes. Remember I said...
So why are we
Yeah, hang on. No, Judge Healy didn't say peacekeepers don't have standing. Judge Healy, his job is, how did he see the facts? Because we are arguing questions of law. Mm-hmm. What Judge Healy said was, peacekeepers wasn't involved in this court case. It was Marc Horn's personal tax matters.
So they're both...
He didn't make a judgment on it. He didn't argue that yes or no, for judicial review, peacekeepers have or haven't got standing. He just stated the fact. Peacekeepers were not the party before him.
At the time.
At the original council tax hearing, the party before him at the time, the fact was, it was Marc's personal tax matters.
Okay.
Okay? So basically, there is no argument about the facts of what happened. Had he disagreed with some of the facts, then he would have put his version of the facts. And provided they're not major issues or discrepancies in the facts, the judicial review, the High Court, will deal with minor discrepancies between facts. But they wouldn't deal with big if most of the case is about facts, you're in the wrong court. That's not what judicial review is for. Okay? So this is what Judge Dame Hill had to resolve. So what we're going to do, so basically, next, how were the parties represented? So Marc Horn, claimant in person on behalf of PeaceKeepers, Simon Whitfield appearing on behalf of the interested party, Liverpool City Council. What the court had was all the submissions from all the parties. So then it goes through the factual background. On the 12th of August, District Judge Healy at Liverpool heard the application, handed down the judgment on 23rd of September, 14th of October, I applied for Section 111. He issued a certificate of refusal on 24th of October. I filed the application for judicial review on 20th of December. Due to delays by the Administrator Office, the claim was issued 24th of January, subsequently transferred to Manchester Administrative Court. The claimant's application for judicial review proceeds on 8 grounds. The renewal application proceeds on 8 grounds because that's already ceded ground 1. And for failure to follow common law precedent and violations of constitutional principles, the misapplication of statutory powers, breaches of the alleging all of these things is what the judicial review, breaches of the open justice principle, procedural irregularities. So that there is in summary what the case is about, what happened and how did it get here. Okay? So it lists then what is the job of the court, what is this court about. So the issues that need to be determined, okay, are whether there's an arguable case with a realistic prospect of success. And to do that, so this here is the ultimate thing that needs dealing with by the courts. But to do that, okay, for the claim, for her to allow it to proceed to a full judicial review hearing, a substantial hearing, every box needs to be ticked. Fail on any one of these 4 boxes, it cannot proceed. Okay? So her job is to go through each box and make a determination whether Judge Ockleton was right in refusing on that ground. Yeah, the judge which made it on paper. The original refusal of the judicial review was on papers by Judge Ockleton.
Was Healy then?
No, Judge Ockleton. Healy has nothing to do with it. His is only the underlying decision. This is moved into a new court, an application for permission for judicial review. Healy's got nothing to do with the total, separate, unrelated matter.
So Ockleton was the result of the Section 111.
No, Healy, District Judge Healy
was Section.
Okay, so let's just unwind this to make sure everybody's clear. District Judge Healy handed down a written judgment and made a liability order against me. I then put in a Section 111 of the Magistrates Court Act for what's called a statement of case for the opinion of the High Court. A statement of case for the opinion of the High Court because I believe District Judge Healy had erred in law, okay, in a whole list of things. Okay? So for instance, there were empty seats in the court, and to me it's irrational to breach the open justice principle if there's members of the public there and there's free seats in the court and there's no health and safety issue. Why on earth can't people sit in them? Whether the public gallery is full is irrelevant. There's other empty seats. totally being wasted. It just seems stupid. And in many other courts, we've actually had judges which allow you to sit there. They've allowed us to sit in the press box. So, and there were, if it would have allowed everybody to come in, there might have only been 2 or 3 people that who travelled, couldn't get in.
So which hearing was that for?
My council tax hearing.
The initial council
Yeah.
tax hearing. Okay.
Yeah. So I'd ask Judge Healy questions of law. Was this reasonable? Was that reasonable? Was this wrong in law? Did you address this? Whatever. Okay? So the section 111, he gave a certificate of refusal. He refused to state a case for the opinion of the High Court. Okay? Now, I'll explain this now, because this actually was one of the waste of time of the High Court's arguments that the barrister used. Okay, it's just, honestly, it's just insane. So, if they state a case, and the reason you can get a statement of case from a magistrate's court or a crown court for the opinion on questions of law for the High Court. The reason for this is, basically, you've got the least experienced people operating in these courts. They have legal advisors who are legal professionals in addition to the lay magistrates. And you've generally got people who are not represented, or you've got a lot of parties which are not represented. That includes people who can't afford to go to solicitor or barrister and get them to put together a judicial review application. So what they've done is, Parliament has put in very sensibly a mechanism whereby you ask the questions and the legal professionals prepare the statement of case for the opinion of the High Court. So it's very rational. It's a very, very good system. It's a good idea. It means I don't have to do it. And it only costs 180 quid for me to go to judicial review. Because that's one form of judicial review called statement of case. Okay, so that's one way of getting into judicial review. The question arises though, if they refuse to state a case, what happens then? Okay? So, you've got 21 days to apply for a statement of case. They have 21 days to respond for a statement of case. So basically, for 42 days you wait in suspense. Am I going to get a statement of case or aren't I? So why are you going to prepare judicial review on the assumption maybe they'll make a certificate of refusal? And certainly, why would I go and pay a barrister or a solicitor company to prepare one just in case they make a certificate of refusal? That's insane. Okay? And this is important, and we'll come to that.
So they have 42 days not to deliver. They have 42 days just to decide whether they do it or not.
No, this is the statement of case. Correct. Within 42, I have 21 days to submit it.
Yeah.
Okay? The date of submission or the filing. I need to ask for a statement of case within 21 days of the decision. They then, from receiving my request, have 21 days to either state a case or refuse to state a case.
Oh, just to think whether they do it or not.
Well, either to do it
Okay.
or not.
Do it.
They either must do it or they don't, then you give a certificate of refusal. They can only refuse to state a case on grounds of frivolous or vexatious. And there's case law on it. We need to really hone in a little bit so people have a better idea of what frivolous, basically, don't waste my time, is what it means. Okay? So, now if they do state a case and give it to you, you have 7 days, or the parties have 7 days to reply and refine it. They then have 7 days to give you back the final statement of the case, including what you've asked him to include. Now, think about it rationally. If he's going to make a certificate of refusal, do you think this guy really is interested in stating a strong case for me? Even if I tell him what to do, he's not going to do it. So there's an alternative remedy, we'll just talk about this now, okay, called an order mandamus. I can go to the High Court and I can say to them, hey listen, I don't know how to prepare a judicial review. Can you instruct District Judge Healy to prepare a statement of case for judicial review? So that I don't know how to do it, or I haven't got the money. But this here really is fallen by the wayside. It's still available. However, it does not preclude you from proceeding immediately to judicial review, because in essence it's deemed a waste of time. Okay? So just remember that, we'll come back to that. Okay, so what happened on the day was District Judge Ockleton dealt with these three first. Any suggestions why? Any suggestions what you can conclude from that?
So it was Ockleton who put them in that way.
No, sorry. Dame Hill.
It's Dame Hill.
Yeah.
Now
Judge Dame Hill said, I'm going to put
30
standing
different
aside,
Yeah.
because if Marc fails on any of these grounds, I don't need to worry about standing. Okay? So what do you think that says?
Got a chance.
Hmm?
Got a chance.
Got standing.
We got standing. So that's before we started. Okay? Now, for standing, briefly, I put in using the court's powers not to defeat an otherwise viable claim. The court has a lot of discretion. And the overriding objective of the courts in CPR1 is to deal with cases fair, justly, and at proportionate costs. And they have a power under 19.3 or 19, don't quote me about the rules, but they have powers to change the parties to make sure cases are dealt with fairly and justly. In fact, they have a duty to do it under the Senior Courts Act. Section 49, the rules of equity impose a duty on the senior courts to deal with cases so as to completely and efficiently resolve all issues of disputes between the parties. This is a duty they have, and apparently this must be the first time anybody stood on that right. So I put in reply to, okay, I put my grounds, they reply to it, I put in a reply to the grounds, but I can only reply to new grounds. Okay, so when I replied with the a lawful test of standing, they ignored that. Okay, and then in reply to that I said, okay, there's one more ground, the powers of substitution by either addition or substituting the claimant. And I gave my consent. You can add me to the claim. No problem at all. I consent to it. Okay? That's why I knew we'd want standing. Either me individually, by them substituting me for PeaceKeepers, or by adding me together with PeaceKeepers. Okay? And this is important for Darren's case, because in Darren's case we've got an absolute clear breach by a deputy district judge, I can't remember the name now, on Darren's costs. She turned around and said, I don't have to determine the costs of the application because that is the valuation tribunal's job. straight in breach of the council tax admin enforcement regulations, straight in breach of Nicholson judgment, and he's got 11 grand costs awarded against him. So at least just that point alone, Darren can change for Peacekeepers, and not only are they not getting their 11 grand costs, because that point we've won, we are claiming 11 grand of costs from them. It's time this nonsense stops.
But was it also possibly the reason she decided not to look at standing in order to stop the barrister from getting stuck in that argument?
Well, to me, okay, let's just assume this here's the biggie. So if there's an issue, if I can't get past here, I don't even need to look at those three.
Yeah, but then she knew that the delay one, the barrister would have to concede.
It was obvious. I mean, the delay one shouldn't even have been spoken about in the court.
Yeah, so
So he didn't have to, again, he wasted probably an hour's court time before he conceded.
Yeah.
Okay? He should have done just like what I did. This is an obvious bullshit argument. I concede delay. Okay, let's move on. Okay? And he should have conceded this with all the desperation that he was doing. And he'd already conceded round 7. I knew I had standing here. I knew this box was ticked. Why? Because he was complaining that District Judge Healy didn't give a reasoned judgment for the argument of valuation tribunal in the original hearing. So already by this, I knew already we've won 2 of the grounds. Already. And there's nothing that anybody can do about it. If you got a corrupt judge and you rule against this, I'll go straight to appeal. No problem. And that there will expose the corruption. Okay? So rationally, this here is the bulk, and within here, this is the bulk, okay, of time and arguments. Here there's 8 different arguments I had to present, okay, rather than just one argument, one argument, one argument. Okay, standing actually is a big argument when you see the detail about how to determine standing. But I knew anyway, with putting in that letter of consent to change me for Peacekeepers, I had standing. End of. It's slam dunk. And absolutely nothing they can do about it.
Well, do you think we can have a 5-minute break, because we'll probably go way
that's
past
fine.
5:30.
Yeah.
Probably go
Calvin,
6.
do you want to just pause it?
Yeah.
Yeah, sorry. Do stop me for breaks, okay? Because I have this tendency to talk.
Thanks for that, Daniela.